Hey, right, everyone, just bear with me a sec. Just doing the usual admin. There we go. In that. And click on this bit over here. Nope, this bit here. And then we'll get going. Hope you guys are all right this week. I am pretty knackered today, but it's been delivering training and stuff. It was cool. Nice bunch of people. Yeah, I think we're all good. Yeah, so yeah, welcome tonight. Usual stuff I'm going to say, as I always do. This isn't legal advice. We're going to do our best here to be helpful, but we obviously can't guarantee answers that are going to be correct if we're, human error, plus the fact we're kind of taking information over the internet, whatever. And if you want to ask questions in the live stream, you absolutely can, but you need to anonymize them. You need to ask the question as if it's about someone else, or a what if question, even better. So your question, if you start your question, what if someone was in temporary accommodation and it was over the 6-week limit on the B&B, what would happen? That's your question. That's the best way to get a sensible answer. We've got 2 questions that have come in through the week. Just to confirm how that works, because I've had a few questions about that actually. If you go onto the YouTube channel, any video on the channel, you can just put a comment and you can ask the question and I'll get a notification. And I've just managed to stress myself out a little bit because some people asked some questions by other means this week. One was on the Facebook page and there's something else as well. And I now can't find some of it. So I'm really, really sorry if someone's expecting me to answer a question. I literally can't find the question. So yeah, apologize if that's you. Just ask the question again on the YouTube channel on the video, and I'll hopefully be able to pick it up next week. Hey, right, Michael. I'm not sure if we've got much news this week. I've got a bit of, I've been continuing to do this this database of LGSO decisions. I found some quite interesting ones, some quite high payments as well. So there's one I was looking at today, which is £21,000 for unsuitable temporary accommodation. And there's a few things like it. Again, I'm trying to hone in on this question we've had from a few weeks ago, which was effectively how long can a single person be expected to stay in a hotel? Because obviously there's this 6-week limit for families, but there's no limit on single people. And so the one I was looking at today again was where it was Birmingham Council, and effectively part of the compensation Birmingham had to pay was for food because it was a family, but this bit would apply to children, to single people, where basically where they're having to get takeaway. So they basically got a payment that covered those costs they were having to pay out. I don't know if you guys have got any gossip. Karis, do you want to talk about your charity, because it seems to be you're up and running now, or kind of getting a bit more, kind of a bit public. But I don't know if you want to. I don't want to put you on the spot. So if you want to kind of save it to another week, that's all good.
No, I don't mind. Thank you. I don't. I wasn't expecting that, but no, I don't mind.
Really sorry.
So Essex Legal Link, yeah. So we work with Essex, but it's about filling the gap and helping people put in complaints. People that aren't entitled to legal aid, and that things that fall outside of the scope of legal aid. There's also workshops on understanding your tenancy. And now we've just been able to, with some volunteers' help, put it on social media and stuff. So it's really good, and our website is out there. But yeah, that's predominantly what we do. So it's all housing, homelessness, and that bit of teaching. So you get support and what the workshops on what your tenancy actually is. But a lot of the legal aid work, that's where people can be represented. There's a big gap compared to what people can afford to pay for and things that fall outside of the scope. So yeah, that's what we try and capture at the Essex Legal Link. So thank you.
I'm assuming you need to be in Essex to get to be eligible for that. Yeah.
Yes, it is fundamentally based in Essex, but we do have discretion with where you are if there's any link with our funding based. And also we do work with other counties. So if you do fall in our lap, we'll work with someone to try and find out where you are, the best place to put you.
Cool. Nice one. Sounds cool. I will be following that on. Well, I've saw it on LinkedIn basically. So I see how you're getting on. That's cool. All right. So let's get into the questions. So Anton, it's all right. I got you. In terms of that question, I just didn't get time to respond to you to say I can do it. So yeah, I'll get to that shortly. In fact, I might do that one first because that one came in a few days ago. Let's get the thing up. Here we go. Honestly, I've got the worst feeling ever that I've forgotten something obvious. But anyway, so this is kind of a two-part really, but we'll do it all at once. So question one for the night: if a person was accepted under prevention duty, and told they were eligible for the rent deposit scheme. Then a housing agency declined their application. Then the council says the person has savings, which isn't true. Then told not eligible for rent deposit scheme anymore. So let's deal with that first. In fact, I just might make this into two questions because they are kind of two questions really. Um, so yeah, basically, the rent deposit scheme, different councils call it different things. Could be a rent bond scheme. I'm sure there are other kind of names they'll get. But the rent deposit scheme is essentially a typical rent deposit scheme is where the council guarantees the deposit and works with private landlords locally to kind of house people. So either they end the duty under the relief duty or something like a final accommodation offer, or they basically house people before it gets to the main duty stage altogether. And the council will set what their kind of checks are. So what the amount of monies you can have now. So I guess the first question is that it sounds like the council's saying that the person has lots of savings, but the homeless applicant themselves are saying they don't, and that appears to be the reason that the kind of the offer's been withdrawn. I guess all you can do in this situation is to basically challenge the council and say you've got this wrong. I haven't got savings. What you're talking about, and then just provide evidence. And really, I'd be interested to know what evidence the council's basing their assessment that there are savings. So you might need to do a subject access request, which is what comes next in the question. But that's kind of what I'd be doing. I'll be just kind of tackling that individual issue and say, look, what the council's got it wrong. This person doesn't have savings, and therefore they are eligible for the rent deposit scheme. So I think that's kind of what I'd say about the first one. Will and Karis, interrupt me if you can see something else. But then if we go to the second question, also the person trying to get the housing file, the subject access request, the council keep trying to get them to withdraw the SAR, which seems odd. They're then told the formal complaint is on hold until the person finds a place. So what's the suggestion for the person? That stinks to me. What I'm surprised, I mean, because you do see this happen where councils they probably can see that they don't want to give the file over because something about it's dodgy. But what they would then generally do is they'll house the person to kind of like, so that hopefully the person doesn't pursue it. So the fact that the council is on the one hand denying housing, but at the same time they're saying that they're not going to give all of the subject access request for files, just it does seem very odd. But what you need to do is basically, well, what I would do is basically push through and get, basically kind of pursue the do want this because there may well be stuff in there which. And in terms of the formal complaint being on hold until the person's found a place again, I don't see any reason why the council would do that. Their policy basically will give their own timeframes, and again, I don't really see what a good reason would be for the council to take that position. I've not seen it before myself, so I've not come across it myself. But I just don't see what their argument would be. They've got their own formal timescales on responding to complaints. I don't know. I'm trying to think if I've ever seen a complaint being delayed. I can't think of a time I've ever seen it being delayed. I've seen it being kind of delayed because they're useless and kind of incompetent, but not kind of deliberately delayed because of something else that's happening. So yeah, I mean, if it was me, a bit of an odd situation, but if it was me, I'd basically pursue the council and say, no, I really want my subject access request files as soon as possible, please. Here's your time limit. Time limit's 30 days. And then also say, no, I want the complaint to go through, to be honest, unless there's a good reason to not to. I mean, there are some times when you can kind of maybe use it as leverage, but I don't think this is one of them. So I think, yeah, I don't know if that answers the questions, but yeah, that's that. If I'm reading them correctly, that's what I'd say. You want to iron out this problem where the council think the person's got too much money, and just say, look, that isn't the case. You might have to, well, you will have to provide bank statements. It will be useful to know where they've got the information from that says you've got more money. But that I think is going to be the response. Will or Karis, you can see anything else with this one at all? Or was that no? Okay, cool. So yeah, that's the first one from the week. The second one from the week is this one here. So this came in from a worker. In short, so this was kind of the actual question. So in short, this person lost their job in January. There was a mix-up with their universal credit, which we tried to fix, but they're unwilling to fix. Because of this, the client ended up having no income for 3 months and fell into rent arrears. Help recently received a Section 21. I think it probably means he recently received a Section 21, but it's been told he has to leave now rather than the date stated on his paperwork, which is still 2 months away. We've applied to the local council for help, and they've said there's nothing they can do and have taken off the housing register. He also applied for local connection in another area where he has family, but he hasn't had anything else since, and we're both unsure what to do now. Then I went back and said, has he told the first council that the landlord is trying to illegally evict him? And they came back to say he has, and they've stated there's nothing they can do to help him, but he was on the housing register, but they've removed him as apparently the wait is too long and there's nothing they can do. Universal Credit has also stopped his payments for rent despite his Section 21 stating he doesn't have to leave until July, and also saying they can't help him. So this is a bit of a mess, but not beyond redemption. So let's kind of deal with these things individually. Let me get the code of guidance up to say a couple of things. So the first thing to say about this is you're homeless if it's unreasonable to continue to occupy your accommodation. One of the reasons that could be because of his unaffordability. And so the benefit issues may well mean this person's already homeless because they can't afford their rent. So all I can say is you need to make a homeless application to the council in writing. If you follow the advice in the video I put on the channel, which is the best way to make a homeless application, and follow those steps to the letter, so don't not follow them, you need to follow them. I don't see how the council is going to basically refuse to help and refuse to accept an application at this point. Particularly since there, as far as we can tell, there's now a valid Section 21, which means you can definitely make a homeless application now. Yeah, so and there's a complaint to be had here probably down the line because they're saying there's nothing they can do. There are definitely things they have to do, let alone they can do. And then if we just drop down a second, because we're going to come back to this middle bit, but saying that essentially there's this kind of potential illegal eviction. Now, again, if the landlord's harassing you and telling you to leave, you can absolutely go to your council, and the council can absolutely take action against the landlord or threaten to. They won't actually do it. So again, that is absolutely part and parcel of their job, is to support tenants to not be illegally evicted. So one of the things that needs to happen is that the tenant needs to not leave, because absolutely there's no they don't want to leave before the Section 21 expires. We then get into that kind of whole world of what point do they become legally homeless, and the answer is probably when the Section 21 expires. So they need to be treated as a homeless person at that point. But yeah, that's kind of, so the council clearly is just shirking a whole bunch of responsibilities. But the way you deal with that is you take it back to basics, you put the application in writing, you complain if they don't comply. And then we've got this middle bit here. He also has applied for local connection in another area where he has family but hasn't heard anything since. So we're both unsure what to do now. So again, I think what this person means here is it's not that they've applied for local connection, because you would have local connection already, but they've made an application, a homeless application, to another council area, which is completely legal to do. You can apply to 2 councils or 10 councils simultaneously. Not always the best thing to do, but you can do it. The reason it's not the best thing to do is that each council will then say it's the other council's job, and it just makes it a mess. But you can legally do it, and councils legally should basically both take the application and work out between themselves who is going to undertake the inquiries. So yes, I think that one of the questions here would be is which area does the person want to live in? Because they can, on these facts here, they can definitely make a homeless application to a council. And if they'd rather make the application to the other council and they do have local connection there, then it's worth doing it. I often say you don't need a local connection to make a homeless application, and that is true. But if it's safe for you to be in an area where you do have a local connection, you will get referred back there. So although you can do it, in most cases it's not worth it unless you're fleeing domestic abuse or something like that. So think how you are, Cheeseface. Michael, that's my answer to this set of questions. I don't know if I've missed anything there. Will or Karis, can you see anything else that I have missed or have I got wrong, or you want to add to it?
Oh,
Go on, Karis.
I was just going to point out the Universal Credit. Sorry if you did mention this. They shouldn't have stopped paying for his rent. You can challenge that and restate that they need to be repaying. And that's also something the housing officer should be helping you with.
Yep. Yeah, good point. I guess, that needs to happen. I think it's kind of complicated by the fact this tenancy is potentially about to end. But yeah, you want to get sorted out.
It's because by the time you get to court and they apply for court, they would have further grounds that you're now 2 months in rent arrears, which is reason to evict you. So you're running into the problem of getting into rent arrears, and that's a mandatory ground for eviction.
Yeah,
Isn't
cool.
it?
Yeah,
Sure.
thank you. That's helpful.
Well, I was going to ask, is there a background to this as to, because it says all this happened because of a mix-up with Universal Credit, and then he seems to have sort of got treated like he's some sort of public enemy number one by the council and other people. Um, but
I
I
mean,
don't, I suppose you don't know that.
yeah, this is all the information I've got. I don't think there's anything unusual at all about councils doing this and saying, "Oh,
No,
there's
no,
nothing we
there
can do."
isn't.
So I don't think that it's personal. But in terms of the
No.
universal credit, I don't know if there's like again if there's kind of I don't know if there's more to it, but I don't I
The-
get the impression there isn't. I think it's just generally a I don't know they haven't applied for the right thing or applied at the right time or something, and it's just kind of led to something stopping.
Then
Um,
it's where it says we've applied to the council for help, and they've said there's nothing they can do. And I mean, that's just the most classic case of gatekeeping, isn't it? That's like them saying sort of what's a homelessness application or what's a housing department? Because of course there's stuff they can do. They can decide whether he's eligible and whether he's threatened with homelessness, and then whether they owe a prevention duty. And he's informed them that it seems the information is that he's being threatened with unlawful eviction, and it's also possible that he's got a a valid Section 21 hasn't expired if it is valid, but they should be looking into what's happening about the threat of eviction. And there's nothing to stop them helping him deal with these problems, even though he's not threatened with homelessness within the next 56 days, even. Sorry, is it for 28? Sorry.
yeah, it's 56 or
Yeah,
two
so
2 months.
I mean, the very least they could give him a Section 184 notice saying, sorry, you're not eligible, we don't think you're homeless, and he could challenge that. But that's the thing with the way in which the law is phrased is that it always puts a hook on local authorities to put a decision in writing. So they can't just say it's to stop exactly this sort of thing. If they really want to say there's nothing they can do, they should put it in a Section 184 notice, and then it can be dealt with. But this is just outrageously bad. So I think he should be looking into taking judicial review. I mean, it depends whether he's got something at the end of the rainbow to sort of get. But I think he has, hasn't he? Because he's at risk of.
There's going to be something useful in there. I'm just looking at I'm not going to say which area this is from, but I'm just going to see if I think it's an illegal aid desert, which might explain why this council has got it so hopelessly wrong. Because I mean, generally, as a general rule, and it's not, yeah, it's just a kind of rule of thumb, councils which don't have a local legal aid funded service challenging them just kind of get into all sorts of ridiculous kind of positions. Whereas a council that's used to being challenged won't be this stupid. They'll make other
Yeah,
types of
yeah.
mistakes, but they generally won't be there. And I think it is. I'm just looking at the map I've got here. I think I know where it's from. I suspect this is an illegal aid desert, as I say, which
Well, it
might kind
shows
of
what happens. Yeah.
yeah, yeah. Well, the good news of that is that it's actually very easy to challenge them. But yeah, you just need to get it all into writing, make the application in writing, following the steps in the video, and be prepared to complain very quickly because obviously there's a lot happening here which is time sensitive, which could end up screwing this guy over. So I think that would be our collective answer to that. Um, so yeah, hopefully there's some stuff that's useful there. If you are watching and you find it useful, give it a like and all that sort of stuff. Give it a, if you haven't subscribed already, think about subscribing. You'll get notifications of new videos. And that brings us into the live stream chat for tonight. There's one question so far. So if you ain't quick, we might finish it before you know it. This is a multi-part, so let me just get this all into one place. Here we go. So person is living in unsuitable accommodation and has major health problems with mobility. Requested review under section 202. Solicitor submitted an appeal. Counsel completely ignored. No decision reply from them. A person spoke with the solicitor recently and the solicitor said it will have to go to court. Will the counsel reply when issued with letter before action? Can you explain this process, please? How long will it might take for the person to be moved into suitable accommodation? Thank you. So I'll let Will or Karis answer this one I have a half an answer, but I know, yeah, this is Will and Carris's bread and butter, really. So yeah, so it's good that this person's got a solicitor. That's good. I guess the first question is the letter before action likely to prompt the council into doing the right thing, or is it likely to go to court? I appreciate that you might not know the answer to that, but let's try and speculate. So, yeah, what do you guys think?
Again, sorry, do you want me to?
Yeah, go for it. Yeah, yeah.
When so unsuitable accommodation, that's under review, and technically they have 8 weeks to do a review. And if the solicitor submit an appeal, that's when they apply to court, and it goes to court. But you're subject to being allocated a hearing at the court. So then you're subject to directions, and they have to do certain things by a certain time. So that part is kind of how long is a piece of string, because it can also be delayed, and you can delay the hearings. They can delay it. But at any point, this can be dealt with outside of court. So to say it will have to go to court, although you've applied to court, the council can do as you've requested without it going to court. So it could be dealt with before going to court. So if you've issued a letter before action, that's 40, it gives them usually 14 days before they send in the paperwork to the Court of Appeal. So
Okay.
you're subject to time limits then, but you are also, those time limits can be extended and the court hearings can be cancelled. Even on the day or the day before, they can be cancelled for no judge to be available, judge illness, no space in the court's overbooked because they expected cases to settle. For a variety of reasons, the court can be cancelled. So it is, how long will it take? It really does depend.
Is given that I mean, it's a little bit like say the person was homeless, and you basically request that the person was housed whilst all this took place. In a case here where the claim is the person's living in unsuitable accommodation due to, sounds like, disabilities, is there any kind of way of kind of making the council house the person in temporary accommodation whilst they wait for it to all happen? Because it sounds like you're saying it could be months in theory, could be a long time before they actually get sorted. But is there any kind of scope just to kind of say, actually, whilst this is up for debate, this person, we just need to kind of make sure this person has got suitable accommodation? Is there anything that can kind of make that happen?
Yeah, so if they requested accommodation pending the review, but then if that's denied, they would have to take it to court. And again, you're subject to, that's a judicial review, which tends to be a bit quicker. But again, that's subject to getting allocated to the court, getting a barrister, and getting everything in. So you are subject to when the court has availability. But it's subject, JRs are usually in the administrative court. So it's a different court, and they sometimes a bit quicker.
And if the person rang up this particular court and said, "Look, what's your average waiting times?" would they be able to give any kind of sensible figure, or are they likely to be
No, because
pretty useless?
You'd be sent to a switchboard who won't have the allocations on the day and won't have the timed listings. So you won't have just a call center that you can phone up and make an appointment or find out when you're next in the queue, because things change all the time.
Okay.
I would go a step further than that and say if you ring up the court, you won't get any information.
Oh yeah.
You'll hold for about last time I tried, you hold for very many minutes, and then you get through to somebody who can tell, like I said last week about housing associations, you get through to somebody who's looking at a computer and says, "Oh yes, I can see that the case number you've given matches the names that you've given, but I'm afraid there's nothing else I can do. Um, Try again." Basically, if you've got a hearing the next day, they might talk to you. But the court system is completely broken down in terms of user friendliness. You won't get through to anyone who can give you an answer to a question on the phone. If you go to a court in person, in the county court, you won't be able to speak to anybody except security, and you won't get a response to an email for a long time. Can I just to go back to answer the question? My take on it is if you're in unsuitable accommodation and you've got major health problems, you are homeless because your accommodation isn't reasonable for you to continue to occupy. Now, you could be in that accommodation because the council, basically because you were there and you haven't made a homeless application, so you could then, but here it looks like they're actually requesting a section 202. Well, it could be that that's because the council said you're not homeless or you're not in priority need or something. But the bottom line is, whenever you're challenging one of these decisions, you've got this backdrop that they have a mandatory duty to provide you with accommodation if you're homeless and in priority need under Section 1, eligible homeless and in priority need under 188. So that means you can steer the thing back so that you keep coming back to that for judicial review. So let's say you've got a Section 202 review going on. You've then, the council has a discretion to accommodate pending the outcome of the review. So you say, please, can you exercise your discretion because I'm in unsuitable accommodation with major health problems. If you're not going to exercise your discretion, will you recognise that I'm actually homeless and accommodate me under Section 188? And then you send them a JR judicial review pre-action letter saying if you don't agree to accommodate for either of these reasons, we will issue judicial review proceedings. And you can, depending on how serious these problems are, you could give them 24 hours warning. And then you could, as long as you've got a solicitor who can get through the steps which Karis mentioned, like getting legal aid, getting a barrister, getting the papers ready, that can, in theory, be done within 24 hours. And so you could get to get them moved into suitable accommodation, you could get an order in judicial review proceedings saying they have to give them suitable accommodation. And if you were really sort of doing it, A grade solicitor, you could do it in a week, if
So,
not even sooner.
yeah, that's so. I mean, the way I read this is it's already gone past the 202 stage. It's now looking at 204.
Well, it
But
mentions an appeal. I'm not quite
yeah,
sure. So I sometimes people mix the terms up, but it says 202 and then it goes on to an appeal. But then it goes, the solicitor wouldn't be sending a letter before action if it was an appeal, because you've got 21 days to appeal from the date of the completion of the 202. What it may mean is the solicitor was going to write a judicial review letter before action, and it doesn't matter. The answer to that one is it doesn't matter if the council reply or not, because what you do with a pre-action letter is you say, I'm going to go to court if I haven't heard from you with a satisfactory answer by X 5 p.m. on X date. And if they don't reply, then you say to the judge, well, we sent this and they haven't replied. The
And
judge
also it
would
says
say,
no
have you phoned
decision.
them?
Sorry.
Sorry, the judge would say, have you phoned the office to check if anyone's dealing with it? And you could say, well, yes, I did. And nobody was picking up the phone, which is the likely answer. Sorry, Karis.
Because it's going on about there's been council completely ignored and there's no decision. So if there's and it also says solicitor submitted an appeal, but then the person spoken with a solicitor recently. So it's kind of a
Confusing, isn't it?
jumbled, there's no
Yeah.
decision. So what is he appealing?
But there must have been a decision to request a 202 because you wouldn't, that's a review of a decision.
Mhm.
okay. So,
But
I mean, I think whichever way we read it, I think the answers in what you're saying there in terms of whichever way it is, the answer's in there. And I mean, I say there's a good chance the solicitor knows what they're doing. So it's just a case of following the kind of steps that just Will and Karis have just outlined and just letting it run its course. I mean, I'm just trying to think because as a non-lawyer, I'm trying to think if there's any potential compensation for it, because when you get to the LGSEO decisions, unsuitable accommodation tends to be like you actually started talking about proper money, like thousands rather than just hundreds. And I don't know whether where would there potentially also be an LGSEO complaint in there, and the LGSEO would not be looking at the decision about whether it was suitable because that's what the courts will be doing, but the LGSEO will be looking at has the council got evidence that they actually undertook a proper suitability assessment, all that kind of stuff. They'll look at did the council follow the right process, and if the answer is no, then actually I think they again without knowing the detail of this case, I think it's potentially worth kind of pursuing under the complaints process once the other stuff's happened. I wouldn't necessarily say you need to start on that right now. I think the priority is obviously getting the court side of things sorted out. but I think there would be a complaint, I think, there, but it would just be kind of about running it through the normal steps, getting a subject access request, looking to see what the consideration of the suitability was. Did the council actually make some inquiries into the medical issues? You know, how did they arrive at their decision that this accommodation was suitable? And if, as I say, the LGSEO can't question the decision if the right steps were taken, but I would suspect that actually this council hasn't actually looked at the right things anyway. That would be a guess. So that might be worth just kind of factoring in as well. But yeah, prioritize the kind of getting accommodation through the court system. Yeah, cool. So just going to check through the questions here. Okay, I don't think I'm not sure if we're going to know the answer to this one, but let's give it a go. So there's two parts, I believe. Oh no, that's hold on a second, copying properly. Let's try that again. I do know how the copy and paste function. No, still don't. Hold on. Good job Shannon's not here. She'd be like rolling her eyes at me. What? Right, this is ridiculous now. I literally, oh gosh, now I've lost everything. Let's try that one more time. So let's select, oh gosh. I would like to say that this is harder than it looks because the way YouTube live chat works. Let's try this one last time. Oh, is that the right one? Yeah, sorry, that is the right. I'm just doing the same right. Yeah, no, that's all good. And then there's a bit more to it, which again, it's not letting me haggle the select. There it is. So yeah, sorry, that's a long way of saying what the situation is. So can councils as landlords cancel a possible unlawful eviction notice against a vulnerable tenant? DWP told them they're vulnerable and to stop housing benefit. So what, DWP told them to stop housing benefit? Or isn't it illegal for DWP to tell housing benefit to stop vulnerable persons' rent? Do councils usually stop vulnerable people with DWP CTR? Remind me what that means. This will come back to me in a minute. I've had a long day. Housing benefit, please. So, well, I don't know. As I say, I'm not fully understanding the question here. But my answer is, I'm sure the council as a landlord can they can cancel a possible unlawful eviction. They can do it. The question is, presumably they don't think it's unlawful. In terms of the DWP stuff, I just don't know. And Shannon does a lot of work with DWP, so she probably know, but she's not here this week. So I don't know the answer to that. I'm sure they can. I'm sure DWP can cancel housing benefit claims or universal credit claims if they have a reason to.
Is that council tax reduction?
Okay, yeah, that probably is.
Maybe
Yeah,
if it's housing benefit. But
I think it is. Yeah. Council
okay,
tax benefit or whatever it's called.
So there is a housing with the council. They'll have a department to sort out your housing benefit. So if it's cancelled their end, you can also put in an email writing to them.
So just to complicate things further, I don't know that CTR does stand for that here because if I actually copy, because there's another bit here. So could the person just confirm what they're talking about when they say CTR? Because I think they're talking about maybe like complex kind of, the complex needs team in the DWP potentially or something. That's my guess. I think this is more of a benefits question than a housing question, to be honest. I mean, I think that's not to say that housing can't help. I think you want to make a homeless application in this situation if you're not able to afford the rent right now, or if if there's an eviction process, a notice kind of been served or whatever. So definitely make a homeless application. But I feel that this is a DWP and benefits question rather than a homeless question per se. So yeah, Martin's saying council tax reduction, but that does, complex team referral. There we go. So that's what they're talking about here. Yeah, no. So it's one of the problems of having about 1 million acronyms for everything. So yeah, I think I don't know. I don't know that we know, but as I say, whatever happens, make a homeless application in writing and sort of see how that goes. So I don't know if you've got any thoughts. Will, you look like you've got some thoughts.
Well, I mean, they're not particularly helpful ones in the sense that the problem is, as I always say, that the question is it lawful or can they do it? And the answer is, yeah, they'll do it. It may not be strictly kosher, as it were. I mean, illegal. I mean, sorry if I sound like so clever. I'm trying to be clever, but illegal. I mean, it's not illegal in the sense that you won't get the flying squad sort of speeding around to the DWP office to sort of bang them all up if they do it. So it's not illegal in that sense. And it may be that the worst thing that would happen is they'd be criticised for it. But the problem with all, and also it happens all the time. This, and vulnerable people are always getting their benefits cut, if I'm not mistaken, and the DWP does that. I mean, that's the one of the problems. But I've got a client at the moment who's mentally ill, schizophrenic, and that she's not been able to maintain her universal credit claim, and it's clear she's almost certainly eligible for it. She's got no idea why they've stopped it. But it's part of the problem for us is that I haven't got legal aid doesn't cover that, so I can't wade in. But they get away with it. I think, yeah, they will. And I'm not quite sure what. I mean, if the council is a landlord, of course they can cancel an unlawful eviction notice by that I think they mean invalid. I mean, if the council have issued a notice which is not lawful, then yeah, they can cancel it. If they don't, the judge will presumably chuck out the possession claim. Am I missing something there?
I don't think so. No, I think yeah, I think that's about as much info as we can give on this one.
It shows half the problem with a legal problem is just setting it out as so you can untangle the threads and look at a straight piece of thread and say, oh, now I see what the problem is. Because it's so difficult for some, especially if you're experiencing the problem, to set it out in a way that other people will understand. Because you've got to be sort of semi-trained in order to do that.
Yeah.
So sorry about if we seem unreceptive.
There's just an addition to the previous questions, well, question 4. So I mean, I'm not quite sure. I'm not sure if this kind of changes what the answer is we gave. So yeah, following on from the question about kind of this unsuitable accommodation, section 202-ish kind of review request made. So then it says this is in response to our conversation. So hi, unfortunately the council hasn't done anything. They didn't accommodate the person pending the review. They didn't reply with a decision even after the extension deadline. Now the person spoke with the solicitor a few days ago and said they will have to go to court. So is that, I mean, so if the review deadline's gone and the extension's gone, is it likely to go to court at this point, or can the council still turn around and actually sort the thing out before it goes there? As I said, I think I've got a feeling we've basically covered it. So but yeah, I don't know if that changes any, or we need to add anything given the additional information. I think between Will and Karis, you kind of covered what the different possibilities are. So yeah, in the meantime, in terms of why legal aid doesn't cover stuff, I don't know the answer to that, but it is what it is. That's the restrictions of the way the sector works. I think I don't think anyone in the whole country thinks that legal aid is working well. Even the people who work in legal aid, I would assume. So yeah. Right, last call for questions, guys. If there's no more questions soon. So there's just, yeah, again, there's more kind of follow up on that question. I think the answer is we don't know what the criteria are for DWP stopping claims or why they might do it. I think I'm not quite, and to be honest, I'm not quite sure. There are some good Facebook groups around benefits. So I have seen some Facebook groups which kind of like are able to answer benefit questions. You could also make a subject access request to the DWP to get a copy of your records, and there would presumably be some kind of decision-making process recorded in those things about why the claim stopped. So again, the problem you might get with that is probably written in kind of with a lot of jargon, but that's an option to find out why they've stopped it. It just, yeah, just kind of, yeah. As I say, I just don't think I don't think we've got the expertise to really kind of know what might be happening. So yeah, as I say, we'll give it 30 seconds, and if not, we'll call it a night for tonight. So I think that's, as I say, if you're the person out there who asked a question during the week and I've not brought it here tonight, I apologise. I literally just can't find it or remember where it came in. I think I responded to all the questions that came in on the YouTube channel. But if they come in on the Facebook group or stuff like that, it just, yeah, I obviously have dropped a ball and I haven't been able to figure out where it's coming from. So yeah. Any final thoughts, Will and Karis?
One final thought. I just a final message to Will. Sorry, I'm Will. Michael MP. I would say where you said the person's spoken with a solicitor and it will have to go to court. I would say, yeah, I agree with the solicitor. That case will definitely have to go to court, and the sooner it goes to court, the better. But the good news is, I think if it does go to court, the person will win.
Yeah, cool. Just a follow-up question there about subject access requests, which ties into it. So generally speaking, subject access requests are provided either in printed, they'll send it to you in the post or they'll email it to you. Now, if you have like a particular kind of difficulty in reading written font or something, and to say to them, look, I need it in a different format, they should be able to, well, they have to make reasonable adjustments to it. So I'm not quite sure what those options might be. But yeah, so in terms of I have yet to see a subject access request provide a recording of phone conversations. My guess is with that is that although they say they'll record it, I think they delete it very quickly before, kind of like on a rolling basis. So again, it's yeah, you'll get the stuff which is kind of on the system. Any kind of messages you've sent in writing, they'll definitely be part of it. But I don't know that kind of calls and stuff like that would be included in it. I'm interested to hear if anyone out there has made a subject access request and received recordings or kind of transcripts of phone calls or
Mm.
whatever.
Cool.
There has another question that's actually just come in. So question, what are we on to? 6. Oh God. Honestly, I do know how to use a computer, guys. I promise. It's literally just make not yeah, make it look I don't. Here we go. I think I've got it this time. So yeah, here we go. Hi, an individual submitted a homeless application to a council due to domestic abuse and vulnerability due to mental health, and is due to be assessed by a psychiatrist for suspected conditions. Is there more to this one? So I can't see. Oh, here we are. Yeah. So some months after the non-priority decision was issued last year to the individual, after feeling stuck and hopeless for the council, the individual asked their social worker, who is aware of their. I assume there's going to be more to this, by the way. So let's just see what I've missed here. So in the meantime, whilst that's kind of coming in, I think there's more to it. Let's just go back a step and just just kind of answer this one. I think this is more straightforward. Should council be advising landlord on how to make Section 21 valid in returning unsecured deposits? I don't see. I think they would. Yeah, I think part of their job is to basically provide any advice around housing. So they certainly can. Yeah, I don't see why a landlord couldn't ask them about stuff around this. It's in the council's interest that landlords follow the law. In terms of unsecured deposits, I'm not familiar. I'm not kind of dealt with any cases involving them. So I don't know if Will or Karis have got kind of more on that, or kind of know what that might be getting at. I don't know if it's if they're basically
Um,
saying that the deposit wasn't in a protection scheme or something,
yeah,
and which case then Section 21 won't be valid, is my understanding. So
yeah,
the council could be telling the landlord, because the deposit's not in a protected scheme, not protected in an official scheme, then that makes the Section 21 invalid. And so the council may well be telling the landlord, no, this is how you do it. I don't know how much detail they go into with that, but as I say, part of a council's job is to challenge kind of unlawful evictions, basically, and just general dodginess from landlords. So I think it does fall into their remit, is I think the answer. So
did we answer the question about solicitors in Bournemouth?
we might have missed it. No, sorry about that. Yeah.
Because I looked
Uh,
it up. If you want the answer,
yeah, please do. I'm now
I
lost
think
that question.
there's only one, and it's Duncan Lewis. And did the question say good solicitors, or just
I think just they'll take solicitors. Although
okay? Because actually,
Duncan Lewis are pretty competent, right?
no, if you'd asked me 10 years ago, I might have been less kind, but I think Duncan Lewis are an excellent firm of solicitors. I just wanted to check if you wanted to comment on that as well. So yeah, they are based at they've got, God, I didn't realize how many offices they've got. They're everywhere. But they have an office in Bournemouth at Wilson House on 2 Lawn Park Road, wherever. I mean, I don't know Bournemouth very well, but that's where it is, Lawn Park Road. And you can go if you Google housing legal aid solicitors Bournemouth, you'll come up with that.
Cool, nice one, thanks, Will. I feel like we're still a bit short on this question. I don't think it makes sense yet. But there's some stuff we can definitely say about question 7. So there's a little bit of a caveat with the law around domestic abuse and priority needs. So the law says that if you are homeless because of domestic abuse, you're automatically in priority needs. But what you'll find is there are occasionally people who they're subject to domestic abuse, but that is not the reason they're homeless. So, for example, let's say you've got a street homeless couple, they met on the streets, so they're already homeless, then they form a relationship, and then there's domestic abuse. They are not homeless because of domestic abuse, and therefore they don't actually get caught within the wording of the Domestic Abuse Act. That does not mean to say they're not vulnerable, they're not in priority need, because it might well be that they're still vulnerable. In fact, they probably are. That's the whole reason the Domestic Abuse Act made it an automatic characteristic, is because being subject to domestic abuse is going to affect your resilience and affect your ability to deal with being homeless. So that's a bit of a backdrop on the kind of beginnings of the question. If you are subject to domestic abuse and the perpetrator is still at large, so they're not in prison or something, then in effect you can approach any council in the country and make a homeless application there. And in one sense, the vast majority of people will automatically be caught in that Domestic Abuse Act definition, and so they will automatically be in priority need. And so in one sense, the vulnerability doesn't really come up directly, because if you're in priority need because you're homeless because of domestic abuse, the council doesn't actually need to look at vulnerability. In fact, they shouldn't really look at vulnerability when it comes to priority need. They might look at mental health issues and so on, because of they need to look at kind of suitability of accommodation, some stuff like that. But yeah, that's so generally speaking, domestic abuse it means that whichever council you approach, you're going to be owed some pretty good duty. And what that means is, because councils, they know that they're going to owe you a duty in most cases, their best line of defense or best line of attack, depending how you look at it, is they'll deny the abuse happened. They'll say, oh, there's no proof, we don't think that's abuse and stuff like that. But there's no police crime reference number or whatever. But those are all, they're not lawful kind of things. The LGSCO is clear that the default position of council should be to believe people who disclose they've been abused. The Homelessness Code of Guidance says that there shouldn't be no blanket policy about expecting police crime reference numbers, and it gives examples of why people might not go to the police. So although evidence is helpful, it's not necessary. And yes, I'm sure that means that some people out there will kind of take the piss a bit, but the vast majority don't. I mean, I think it's kind of worth saying that there are very few people in my experience who will lie to get housed. The vast majority of people are just being honest. So there is more to it, but again, my copy and paste function, do you know what? I know what it is. It's because I'm on 2 screens. So let's just try that again. Here we go. Yeah. So the individual asked their social worker who is aware of their situation to write a letter detailing the domestic abuse to supplement as evidence for an exemption from the shared accommodation rate under DWP, and also the general housing case. Again, there might be more to this. So again, just kind of talking in general terms until we get the full question. And I did a video about this, which might be worth watching, because there is a difference in evidential thresholds with domestic abuse depending on which government department you're dealing with at the time. So when you make a homeless application, the evidential threshold's low. As that is to say, the amount of evidence you need is a low threshold. Whereas under Part 6, under the general kind of housing register process, the council can basically have their own policy, and often they'll say there needs to be a letter from a statutory professional. And when it comes to getting the exemption from the DWP shared accommodation rate, which would normally apply to people under the age of 35, I'm pretty sure, and again, you need to check out the video, I did recently, but basically I think it says there needs to be a letter from a professional to evidence the fact that you've been subject to domestic abuse at any time since your 16th birthday. I think that's the wording or something like that. So the social worker having that evidence is going to be helpful. I'm just trying to work out, because we've got 2 kind of things relating to domestic abuse happening here. But I guess just to kind of say, it's very difficult for the council to reach a non-priority decision legitimately. So I would say make a fresh application with this social worker's letter for a start. That's new information that's going to be able to trigger a fresh application. So yeah, I mean, so yeah, so okay. So basically, yeah, I think this is the last bit of the question. The individual is living at home with their abuser at the moment and has pivoted back to reviewing the non-priority decision by the council. Could the council force them down the private route? So I would argue that, I mean, you can do it that way. I would argue that it's they're asking for a review of the non-priority decision is not as good in this situation as just triggering a fresh application with the new information, because that's a low threshold throughout. The council would be under a duty to provide safe, suitable accommodation for this person. So that's what I would do. What I think this person needs to do is basically find a domestic abuse service who know what they're doing, which is a bit of a lottery. But I think this person is going to need help with this, because it seems to me like, by the sound of it, this person will be legally homeless because of the abuse, because it's likely to continue. Therefore, they'll be in priority needs. The non-priority decision was probably a bit of a joke, to be honest, because it's very that just seems very, very unlawful to me. So but I think ultimately I would be looking to make a fresh application in this situation. Now, the final question here about could the council force them down the private rented route? Yes, they can. So no matter which duty is owed to you, whether it's the main duty, whether it's the duties owed in the relief duty, the council can always discharge their duty into the private rented sector, provided it's decent quality private rented, provided it's affordable, and provided that it's a 12-month tenancy if it's the main housing duty. So I'm hoping within what I've just said there is useful information for this person, and it's very annoying that the council issued a non-priority decision. But I would just trigger a fresh application. In one sense, if the non-priority decision was issued last year, then you're already outside the review time anyway. So I'd be just triggering a fresh application and probably just use the social worker's letter as evidence for that if you've already got that. So there's a bit more to it, which I think makes sense here. So to the individual pursuing an exemption for the so obviously the focus, you're absolutely right, the focus at this point in time is going to be challenging the non-priority decision, or making a fresh application and getting the council to accept they're in priority need, because at that point or even if there's reason to believe there might be in priority needs, the council have to make suitable accommodation available to them. So that's I don't know, as I say, I'm hoping there's some useful stuff in there. Will or Karis, have I missed anything? Is there anything else that would be useful to say?
No, I don't think so.
So I think person needs to make a fresh application, ideally supported by a competent professional, and that I think would probably provide a safe accommodation route for them. And basically the single room exemption rate would kind of would kick in later. So I think that's it then, guys. Thanks very much for attending tonight. Will and Karis, thanks very much for being here. Will, you're not about on Monday, but
No.
we'll be back on this channel in a week's time on Thursday. Keep the questions coming, guys. Just as I say, best way to do it is on any video on the channel rather than using the live stream, just so you can avoid the character limit. And then we'll get around to answering the questions as soon as we can, really. So as I say, for those people out there, keep going, keep it methodical. That's your best weapon against councils, really. Just kind of keep going back to putting it in writing, kind of make following up emails, complaining as soon as possible. As soon as there's a reason to complain, just complain. That's really the only way to get councils to follow the law in most cases these days. So we'll hopefully see you next Thursday.